Hello dear viewers, today we take up a lesson on the definition of law. The problem of the definition of law is as old as Greek and Roman legal philosophy itself. There have been conflicting and divergent views of the jurists regarding the nature, concept, basis, purposes and functions of law. Roscoe Pound in his work An Introduction to the Philosophy of Law has given no less than 12 concepts of law. Law has been regarded as a divinely ordained rule or a tradition of the old customs or a recorded wisdom of the wise men or a philosophically discovered system of principles which expresses the nature of things, or a body of ascertainments and a declaration of an eternal and immutable moral code, or a body of agreements of men in politically organized society, or a reflection of divine reason, or a body of rules discovered by human experience, or a body of rules developed through juristic writings and judicial decisions, or a body of rules imposed on men in society by a dominant class, or a body of rules in terms of economic and social goals of the individuals. Law can also be defined from the point of view of theologians, philosophers, historians, political scientists and other social scientists. As there are different approaches of the various schools of jurisprudence, there is no general definition of law which includes all the aspects of law. In fact, every jurist's definition of law is tainted by the approach of particular school to which the propounder of the definition belongs. Law can also be defined in terms of its nature, its source, its effects and its method. Therefore, it is not desirable to adhere rigidly to any one definition of law. However, scientific and workable definition is necessary for logical understanding of law. In fact, before John Austin, the concept of law was not clear, certain and definite. It was mingled with other disciplines such as theology, philosophy, ethics and metaphysics. So, the definition, meaning and scope of law was vague and unascertainable. The credit of defining law systematically for the first time goes to John Austin, who in his Province of Jurisprudence determined, took pains to distinguish laws properly so called from laws improperly so called, and also to distinguish positive law from positive morality. Law, the problem of definition. Controversy surrounds not only the acceptability of many attempts to define law, but also the very possibility of producing a precise definition. To define is to state with an acceptable degree of precision the sets of properties possessed by the phenomenon, which is to be defined, that is, to determine its essential qualities. As law is a dynamic concept, to give a universal and uniform definition of law is a difficult task. There are different legal systems in the world. The major legal systems of the world have been classified into various families. India belongs to the common law family. The growth and development of law in different countries has been simultaneous and under different social, political, economic, religious and cultural setting. The words used for law in different countries convey different meanings. On the other hand, the evolution of society being of a dynamic nature, there is an interaction between social change and legal change. The rapid changes in modern times are giving birth to new problems and issues. As a result, law is emerging to provide solutions to these problems. Thus, law is an evolutionary phenomenon. Law cannot afford to be static. The evolution of law has been conditioned by a number of factors, including religion, culture, ethical aspects, social facts, political ideology, economic conditions, scientific inventions, and technological developments. Law has to play a new role in scientific era. However, despite all these difficulties, scholars of various times and places have made their approaches to the study of law from different angles. They have defined law, determined its sources and nature, and discussed its purpose and ends. This systematic thought about law is termed legal theory or legal philosophy. To explain a thing is easier than to define it. To give a definition of law is comparatively more difficult task due to many reasons. In all societies, from primitive to modern, in one form or the other, there is law. The difference between the laws of the societies is not only that of the stage of development, but it is in characteristics also. The term law means and includes different things in different societies. The corresponding word for the term law in Hindu system is dharma. In Islamic system, it is hukum. In Roman, it is jus. In French, it is droit. And in German, it is Recht. In Italian, it is diritto. These words convey different meanings and ideas. Any definition of law which fails to include all these meanings would not be a good definition. Different definitions of the same thing may be given from different angles. Various schools of jurisprudence have defined law from different angles. Some have defined law on the basis of its nature. Some have concentrated mainly on its sources. Some in terms of its ends or purpose. Some in terms of its content, and so on. A definition which does not cover all the aspects would be an imperfect definition. Law is a social science. It grows and develops with the society. Therefore, it is very difficult for a definition of law given at a particular time to remain valid for all times to come. A definition which is most satisfactory today might prove narrow and incomplete tomorrow. As Keaton observed, to attempt to establish a single satisfactory definition of law is to seek to confine jurisprudence within a straitjacket from which it is continually striving to escape. Law is an evolutionary phenomenon. It is a dynamic concept. There are several premises which contribute to the evolution of law, such as political ideology, like that which determines the form of the society as democratic, socialistic, or totalitarian. Economic conditions, like the concentration of wealth in a small minority, leaving the vast majority without means of production but only working skill. Moral philosophy, as that which insists on the security of marriage. Ethics, as in the disgorgement of unjust enrichment. Actuarial predictions, as an overpopulation and possible catastrophic famine. And scientific development, which may harm life of the people. An inquiry into the evolution of law with reference to the above said and other basic premises provides a theoretical basis for reforming laws in order to make law effective and real instruments of social progress. The information we gather by such an inquiry is called legal theory. In spite of the difficulties in defining the law, attempts have been made by the jurists belonging to different schools of thought in this regard. Some of the major approaches to the definition of law is outlined herein. The imperative definition of law. Under this head, it is proposed to discuss definition of law by Austin, Holland, Gray, and Salmond, who belong to imperative school of legal thought. Austin's definition of law. The work of John Austin, who expounded the concept of analytical positivism, defined law as a command of the sovereign which is enforceable by sanction. He defined law in terms of sovereign and defined sovereign in terms of state. As Patton pointed out, the definition of law in terms of the state possesses certain advantages. It gives a clear-cut and simple test. Austin created a legal system in which he gave no place to values, morality, idealism, and justice. His science of jurisprudence centered around sovereign, command, duty, and sanction. Austin's main concern was to give a logically coherent definition of law as distinguished from divine law and positive morality. A detailed analysis of Austin's definition and his theory of sovereignty, including the criticism of Austin's law, is discussed in the forthcoming lessons. Holland's definition of law. The next important jurist who followed Austin's concept is Thomas Erskine Holland. In his work, Elements of Jurisprudence, he attempted to define law more scientifically and analytically. According to him, law is a general rule of external human action enforced by a political sovereign. Holland also defined law with reference to sovereign, devoid of moral, ethical, or ideal elements. Both Austin and Holland had defined law with reference to sanction without bothering for the ends of law. Definition of law by Gray. Another important follower of Austin is John Chipman Gray of the United States of America. He, in his work, The Nature and Sources of Law, says, law of the state or of any organized body of men is composed of the rules which the courts, that is, the judicial organs of that body, lay down for the determination of legal rights and duties. In other words, law is what the courts lay down in determining legal rights and duties of the citizens. Gray is not an Austinian. He is a functionalist defining law in terms of judicial process. However, Gray, like Austin, is concerned with the nature of law rather than its purposes and ends. Salmond's definition of law. Another important jurist of the imperative school of jurisprudence is Sir John Salmond from New Zealand. Like Gray, Salmond also defines law in terms of judicial process. He has also substituted for the political sovereign the courts of law as real source of law. One version of realism was held by Salmond. Before we consider Salmond's definition of law, it would be appropriate to discuss how far he is Austinian. Salmond is Austinian or Neo-Austinian in the sense that he correlates law with the state as the source of law. He emphasizes the authority of the state, especially courts who act upon the rules of law. Salmond's definition of law indeed attempts to remove all the shortcomings of the definition of law propounded by Austin. All law, according to Salmond, is not made by the legislature. In England, much of it is made by the law courts. It is therefore to the courts and not to the legislature that we must go to ascertain the true nature of law. Accordingly, he defined law as the body of principles recognized and applied by the state in the administration of justice, as the rules recognized and acted on by the courts of justice. For Salmond, law means civil law, that is, the law of the land. The second thing which he emphasized is that law must be recognized and applied by the state, that is, courts in the administration of justice. This raises the question about the meaning of the word court. Does it include administrative tribunals? In many cases, the decision of an administrative officer is final. Suppose that the administrative officer lays down a rule that he intends to follow in exercising his discretion. Will he be considered as court and his decision as law? Again, there are other persons and bodies besides the law courts and administrators who enforce rules of conduct. Legislature will take up questions of their own privileges and of contempt against the House. In the Sheriff of Middlesex's case, the sheriff was imprisoned by order of the House of Commons for attempting to enforce the judgment of a court of law. The act done by the sheriff was in accordance with the law enforced by the law courts. Could it be said to be against a system of law enforced by the House of Commons? To this objection, Salmon's reply is that these are marginal cases and all words will have relatively fixed central core of meaning and also some hazy marginal sense, and that the word law is not an exception. Another objection is that though Salmon's definition may be appropriate about case law, it is not appropriate to statute law. Statute is law as soon as it is passed. It does not have to wait for recognition by the courts before becoming the law. Statutes are recognized by the courts because they are law. They are not law simply by virtue of judicial recognition. To this, the reply is that so long as the legislature and courts function in harmony, it does not matter whether we say a statute is law because the courts recognized it or the courts recognize and apply a statute because it is law. The statements are simply two aspects of a single truth. A practical problem may arise when a statute passed by the legislature is declared void by the courts. A political issue may then arise. This will be a case of disharmony between the legislature and the courts, and so long as the state of equilibrium is not reached, no one can answer whether such a statute will fall within law. But according to Salmon, it is a marginal case which cannot influence the definition. Vinogradov criticizes the Salmon's definition and says the direct purpose for which judges act is, after all, the application of law. A definition of law starting from their action would therefore be somewhat like the definition of a motor car as a vehicle driven by a chauffeur, or that of what should we think of a definition of medicine as a drug prescribed by a doctor. Definition of law in terms of the judicial process. In the United States of America, the definition of law in terms of the judicial process is very popular. Justice Oliver Wendell Holmes has said, "The prophecies of what the courts will do in fact and nothing more pretentious are what I mean by law." This definition has been seized by a number of American realists like Jerome Frank, Carl Llewellyn, and Justice Cardozo. The realists regard law as collection of decisions and judgments and not as a body of rules. Holmes was the first to emphasize a pragmatic theory of law by saying that the life of law has not been logic, it has been experience. As Patton pointed out, the practical advantage of such an approach is that it emphasizes the fact that law is a process, that it is not a series of particular commands, but rather a body of principles slowly evolved by the decisions of concrete cases. Definition of law in terms of its purpose. Salmon retains the emphasis on the judicial process, but considers that a reference to the purpose of law is essential. The law may be defined as the body of principles recognized and applied by the state in the administration of justice. Justice is the end of law. and law is defined as an instrument of justice. This raises the question of relationship of law and justice. One theory defines law in terms of justice, but from this it follows that an unjust law cannot exist. Thus, earlier theories of natural law put the emphasis on justice and denied the validity of law if it was opposed to natural justice. But slavery, condemned by natural law, yet existed in the legal systems of the time. It shows that law does not cease to be such merely because it is unjust. As pattern questions, is it accurate then to define law by reference to a quality which actual laws in force may lack? Another theory defines justice in terms of law. A second means of solving the problem of the relationship of law and justice is to place all the emphasis on law and regard justice as mere conformity to law. Jethro Brown suggests that justice as a concept of jurisprudence is mere conformity to law. In this sense, law cannot be unjust, since the term just is defined only as that which is legal. Each of these approaches is founded on false premises. We must distinguish clearly between justice and law, for each is a different conception. Law is that which is actually in force, whether it be good or bad. Justice is an ideal founded in the moral nature of man. The conception of justice may develop as man's understanding develops, but justice is not limited by what happens in the actual world of fact. It is wrong, however, to regard law and justice as entirely unrelated. Justice acts within the law as well as providing an external test by which the law may be judged. Salmon's point is not that law is justice, but that law is an instrument by which justice can be achieved. Paton points out that we may agree with Salmon that the purpose of law is essential to an understanding of its real nature, but the pursuit of justice is not the only purpose of law. The law of any period serves many ends, and those ends will vary as the decades roll by. Definition of law in terms of ideals and values. The law has also been defined in terms of higher ideals and abstract values since the time of the ancient Greek and Roman philosophers. The jurists in different legal systems of the world emphasized the ethical or moral element in law to build an ideal system of law. As such, law has been defined in terms of the nature, in terms of human reason, and in terms of values and ideals. Thus, a philosophy of law in terms of ideals of eternal, immutable, and everlasting character emerged to maintain or change the existing legal and political institutions. Cicero, Grotius, Thomas Aquinas, Kant, Stamler, Fuller, and Radbrush have given formal definitions of law to suit the exigencies of different times. The quest for justice, equality, and ethical values as ultimate ends of law has been the theme of these philosophical jurists. Definition of law as a social fact. Dugay makes a determined assault on many of the traditional theories of jurisprudence. He emphatically rejects any a priori method and prefers to draw his theory from an investigation of the facts of the life itself. He wishes to separate jurisprudence entirely from ethics and metaphysics. Instead of beginning with a concept of the individual man and considering his rights against society, he thinks of man as living in society, bound by his own necessities to share the common life. Hence, the foundation of law is not the right of the individual, but the essential requirements of community life. Law arises because men live together and can only live together. Law does not depend on the will of the sovereign. Duguay rejects the theory that certain persons govern and that others obey. According to him, the governing clause does not create law. It arises directly out of the facts. The ruler is bound hand and foot by a law which he cannot change. Law does not lay down an absolute imperative that this end must be pursued because it is good in itself. But rather, if such an end is not sought, this will cause a social reaction and lack of harmony. Man must realize that if he does not observe the canons of social life, he will suffer from the displeasure of his fellows. The foundation of law thus depends on the social facts. To conclude with the observation of Levy-Aumann, who aptly says that a definition of law should have two aims. Firstly, to make precise the meaning of law, and secondly, to call up in the mind of the reader a true picture of law and its operation. The exercise that has been carried on in this lesson is not to furnish a catalogue of definitions of law and their merits and demerits, but to demonstrate the difficulties in defining the law with an acceptable precision because of different thoughts of different juries at different times to serve different purposes.